Division 1 is now in session.
Be seated. Good morning. Now is the time set for oral argument in cause number 1 CACV 130428, Fisher versus Edgerton. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you can go up on the internet and critique your performance in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. However, ultimately, it's your responsibility to save that time. We have reviewed the briefs and conferenced the case, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in addressing the court this morning. Counsel, when you come to the podium, and I would ask that you state your name and who you represent. And with that, counsel, you may begin.
Thank you, Your Honor. Christopher Robbins here on behalf of Susan Fisher. Your Honors, I'll attempt to save 5 minutes for the next argument and for rebuttal. This case involves a straightforward application of the clear and plain language of Rule 77F. The rule instructs the court to compare, quote, the judgment on the trial de novo, close quote, to the monetary or other relief granted by the arbitration award. The judgment on the trial de novo was in the amount of $20,523, which is far more than 23% more favorable to my client, Susan Fisher, than the $30,152.70 arbitration award. In fact, it's about 32% better if my calculations are correct. And that's really about it. She does not have to pay any sanctions under Rule 77F because she did better than 23% better. Now, what Edgerton wants the courts to do is to break apart the arbitration award and break apart the judgment and compare Fisher to Peterson, the plaintiff, and Fisher to herself. But the rule doesn't allow that, and this court in Valor v. Lee did not allow that. Valor is the one case directly on point. It's a car accident. The plaintiff sues two defendants, just like in this case. The plaintiff succeeds against one defendant, but not the other. Now, the Valor court held that in this exact situation, all three parties must be part of the trial de novo, and that the court would not break down the arbitration award and affirm a part of it, but allow the appeal to go forward on the others. And I want you to notice that Edgerton cannot cite to any legal authority as to why you should ignore the plain and clear language of the rule. And she cannot cite to a single case anywhere that allows sanctions against one defendant to a co-defendant. Now, that's perfectly consistent with everything else we do in civil litigation. Defendants obviously can work together, they can work against each other, but one defendant owes no obligations to another defendant and is never liable to a co-defendant for costs or attorney's fees or expert fees or Rule 68 sanctions.
Okay, counsel, so
Yes.
if one defendant appeals, then you're saying that the other defendant, because we know they've got to be included in that appeal, correct?
Under Valor versus Lee.
Valor's pretty straight up on that. Your position is that regardless of the outcome, regardless of the gain or loss, that defendant is in it and has no hope of recovering if the appeal turns out to be frivolous.
The situation, I believe, Your Honor, is that Edgerton would have had been entitled to sanctions against the plaintiff. It was really plaintiff's appeal.
Under what circumstance?
Under this exact circumstances, if sanctions are at all awardable, they would have been awarded against the plaintiff, because the plaintiff is the one who dragged Edgerton into this case. The plaintiff was the one who filed a meritless claim and got a zero defense
Plaintiff didn't
verdict.
appeal.
Yes, that's true.
Well, that's the problem, isn't it? Under the strict reading of the rule, the plaintiff was an appellee.
Well, and we also have, I'm sorry,
But, okay,
we also have comparative fault issues. To name a non-party at fault is one thing, but to go forward with a non-party at fault status, if you will, in a case means a plaintiff's looking at potentially an empty chair defense that says they're not here and you should give 100% liability to them, and the plaintiff end up with a judgment they can't collect, right?
that's always the situation, Your Honor. That's always the situation the plaintiff faces.
But isn't that what Valor's intended to prevent?
Yes. And let me say this. They actually cited a case that I think fully supports this position. And of course, the name is going to escape me right now. I believe it's the Washington case, which says you look at which parties have a claim against another party, which parties can obtain relief against another party. Neither Fisher nor Edgerton asserted a claim against the other. Neither Fisher
But
nor
Fisher-
Edgerton received any relief.
But Fisher, I think it's undisputed, I mean, at least we don't have the transcripts, but from reading the briefs, Fisher actively sought to shift liability to Edgerton. That's what the answering brief points, and you don't dispute that. So even though there's not a formal, quote, claim, like a cross-claim, one defendant is saying, Fisher's saying, it's all Edgerton's fault. Or it's mainly Edgerton's fault.
And that's
she loses on that.
And that's why, essentially, it's plaintiff's appeal. Plaintiff is riding on the coattails here. If plaintiff thought she could do better than a defense verdict against Edgerton, then plaintiff should have appealed. And if she didn't
Plaintiff
believe
didn't
that,
care.
Excuse me?
Plaintiff is happy with the judgment. She doesn't care who the judgment's against. She's just happy with the judgment. She doesn't appeal. So what you're
right.
saying is, well, she becomes the appellant simply because Fisher appealed.
in essence, because the alternative is that she settle. If she's perfectly satisfied with the judgment against Edgerton, she settle.
But, Edgerton could have said, Fisher your client could have said, there's no way I can prove that Edgerton was at fault. And could have gone to the plaintiff and said, let's face it, no one's going to be able to prove Edgerton's fault. So why don't we enter into a stipulation and let Edgerton out? And you can come after me, and the real issue here is the amount of damages. But that didn't happen either, did it?
No, that didn't happen. Fisher was not the one who initiated it. Fisher was following the case law as she read it, saying that I have to name. She doesn't really care.
Right, but
what she's seeking relief from is the only relief granted in this case was the monetary relief in favor of plaintiff.
But she takes the appeal.
Right.
Oh, I'm sorry.
Well, I wanted to follow up on that and the statement you made about the plain language of 77F didn't allow the award. Focusing on the sentence that says if the judgment on the trial de novo is not more favorable by at least 23% than the monetary relief, or more favorable than the other relief granted by the arbitration award. What does that mean? Because you're arguing only as to the monetary relief. Couldn't that be read to say the comparative fault allocation is not more favorable? I mean, what does that clause mean if it doesn't mean something beyond monetary relief?
I'm not sure what that clause means, Your Honor, quite frankly. Presumably it means something. I suppose there's declaratory relief, specific performance,
That's not available in compulsory arbitration.
Yeah.
Only monetary claims for monetary relief of $50,000 or less. So that phrase to mean something could mean that it's not more favorable. I'm just trying to find meaning to that phrase, because you started out by saying that plain language doesn't allow it, but I'm not sure what that quote-unquote plain language means.
Well, what I meant by the plain language is that it says compare the judgment as a whole to the arbitration award as a whole. And in this case, there really was only one type of relief sought by the plaintiff, and that was she wanted money to compensate her for injuries. There was only one type of relief granted in either the arbitration award or the judgment, and then so comparing apples to apples, Fisher did much better. There's just how could you, I was trying to think of this as well, as when there is no claim between Fisher and Edgerton and there's no relief granted between Fisher and Edgerton, how can you do better or worse? I mean, it's just
There's no claim, because in these kinds of cases you have comparative fault versus the need for a cross claim. In a civil presumably in a contract claim or another claim where plaintiff sues two defendants, one defendant may bring a cross claim against the other defendant. You don't need to do that in this case, because you're saying it's because it's comparative fault, but it's the equivalent of a cross, in essence, of a cross. If I'm 10% liable, it's because that person did it, and that's the equivalent of cross claim. It's just we don't use that language, and the or other relief may be taking care of that. I mean, take a look at. I'm trying to come up with a hypothetical to sort of.
it's difficult because this situation has never happened before.
Imagine you have $100,000 liability after arbitration, and it's 50-50, and it comes up, and Fisher appeals, and she gets hit with 25. It's $100,000 again, but now only 25% liability. You're saying your client couldn't seek fees against Edgerton if Edgerton went after her for trying to say it was all her fault?
I believe I am saying that, Your Honor.
Aren't you also saying, excuse me, isn't it also entirely possible that the outcome of what you're suggesting in regard to Edgerton should have appealed if Edgerton anticipated an award, which is your position, correct? Obtaining an award?
Right. No, actually, I think I was saying the plaintiff should have appealed if she was unhappy with the zero verdict against Edgerton.
But as Judge Kessler said,
Yeah.
she didn't care. But it strikes me that under certain of the scenarios that we've talked about, rather than resulting in what 77F was intended to do, or Rule 77 was intended to do, which is to cut down where there's a reasonable arbitration outcome, cut down on appeals, it almost mandates appeals. It almost puts a party in a position where they have to appeal. They have to file an appeal of those things. Do you see that coming about as a result of any of this? Do you not believe that that would be an outcome of parsing out the 77F award the way you're suggesting?
No, I'm actually, Your Honor, I'm arguing against parsing it out. I'm saying look at the monetary relief granted in the trial de novo and compare that to the monetary relief granted in the arbitration award, and don't parse it out at all, which is also, I believe, the position in Valor, is we're just going to look at the whole judgment on the trial de novo. We're going to look at the whole arbitration award. We're going to compare them. If Fisher does 23% better, and she did much better than that in this case, then she does no fees to anybody.
But that's only as to the plaintiff and Fisher. Edgerton's just a hanger-on out there.
No, she is, and there are ways that she could have escaped. She could have gone to the plaintiff and said, look, she could have come to Fisher. She could have come to the plaintiff and Fisher and said, look, you guys don't care about me. Let me out. I don't have to incur any fees. I don't have to incur any costs. I don't have to do anything. Just let me out. It's done. It's over and done.
That would be a different case, because we don't know what happened. We don't know if she did that and either Fisher or the plaintiff said no.
No, there's no evidence that happened in this case, Your Honor.
Because we don't really know. And
I think I can say fairly confidently that it did not it's not just that we don't know, it's that it did not happen.
Go ahead, sorry.
Did Edgerton suggest to anyone? Excuse me, did Fisher suggest to anyone, let's let Edgerton out of this case?
I don't believe so, Your Honor, no.
So effectively, at the end of the day, Edgerton is just kind of on a whip into this thing. Whatever goes on between the plaintiff and Fisher is controlled by Rule 77F, and if Edgerton is required to run up, if Edgerton gets a zero liability determination and runs up $100,000 in attorney's fees in the course, that's just the cost of doing business.
Or you pursue the plaintiff who dragged you into this lawsuit, filed a meritless lawsuit against
But
you.
the plaintiff wasn't the appellant. And so the plaintiff gets out by saying, I
Well,
didn't appeal.
but effectively, the plaintiff has become, if there's really going to be a controversy about comparative fault by Edgerton, then the plaintiff really is, for all intents and purposes, the appellant here.
So we're back to that position where Edgerton would almost have to file an appeal in order to entitle her to claim 77F relief at the end of the litigation.
No, because the appellant can never claim Rule 77F relief. It's only the appellee who can recover sanctions under Rule 77F.
Thank you. You're down to
me-
that 5, counsel.
Okay, let me take 2 minutes then, address the constitutional issues.
Do you have any case that holds that these fee award cases in arbitration are unconstitutional? Any case?
Do we have any case? No, I don't believe so, Your Honor, because the right to a trial by jury has always been preserved, and that's what makes this whole compulsory arbitration scheme preserved.
But do you
And
have
so,
any case that comes down and says that this violates that right, or it chills that right?
no, I don't believe so, Your Honor. And we also don't have any case that deals with a multi-party simple tort case in which one defendant is entitled to recover sanctions against the other defendant. We don't have any case anywhere in the
I
country.
understand that.
And so let me just ask, what defendant or plaintiff would ever appeal an arbitration award and do better by $10,000 if that party knew they would turn around and have to be ordered to pay $15,000 to another party? It's under the ruling as it currently stands, no party could ever make an informed decision whether to appeal an unreasonable arbitration award, and thus the trial court's holding on Rule 77F in this case, it not only infringes upon it tramples the right to a trial by jury.
How about chills the right to?
Okay, it chills the right because you're never going to seek $10,000 betterment against one party and then be ordered to pay $15,000 to another party.
Right.
That's never going to happen.
Of course.
You could never do anything.
But might find that $15,000 is unreasonable.
Might. Didn't in this case. Thank you, Your Honors. I will reserve the remaining time for rebuttal.
Good morning, Your Honors. I'm Tim Thomason for Amy Edgerton. I would submit that the appropriate approach is a common sense approach. Fisher appealed. We were a party to that appeal. We won. The rule was specifically intended to benefit parties like us who participate in appeals and win. And I would submit that the language or other relief does have meaning and is directly applicable in this case. Now, Fisher, I would submit, actually posits an exception. And the exception that they posit is if I win against one party, that somehow prevents sanctions to another party to the appeal. That's not what the rule says, and it defies common sense. Let me posit a hypothetical. What if the plaintiff appeals in a case where the arbitration award has a $10,000 award against defendant A and a $10,000 award against B? We have a trial de novo. The plaintiff now gets $30,000 from party A, but zero against, I'll submit, my client, party B. I now submit an application for award of attorney's fees under Rule 77. If the plaintiff is correct, I don't get them there because the plaintiff won another part of the case. One, in fact, did better on the entirety of the case. And, Your Honors, I would submit that simply doesn't make sense and was not what this rule was intended to do. In that particular case, defendant B clearly was the prevailing party and clearly shouldn't have been in there. But under their scenario, because they won part of the case, you can't get sanctions in another part. Your Honors, you simply have to apply this rule on a party-by-party basis or it makes no sense. For example, another example, what if the defendant appeals and doesn't do better than 23%, but wins big on a third-party claim? That defendant could say, well, I won part of the case, so I shouldn't be sanctioned vis-a-vis the plaintiff. But that doesn't make sense either. Here, we were included in this appeal, and I would add somewhat parenthetically, but I think it's important, but I don't think it's determinative, but it is important, and the court I know inquired about this. Fisher was directly adverse to Edgerton. Let's make no mistake about this. The joint pretrial statement, which we cited, I think it's record item 36, page 4. This is Fisher's statement. In Fisher's part of the joint pretrial statement, Fisher affirmatively alleges the defendant, co-defendant Amy Edgerton's conduct in whole or in part directly and proximately caused the accident. Sure, that's not an affirmative claim per se, but we were clearly adverse. And in fact, in the joint pretrial statement, there's an accident reconstructionist that was listed who testified solely that this was Edgerton's fault.
So there was a liability shifting going on at that point.
Absolutely, Your Honor. It was.
And this was at the trial?
That was a main issue at the arbitration, and it was a main issue at the trial.
So now we're back to what I was asking earlier. Effectively, if we go with Fisher's position, then Edgerton, is kind of a hanger-on at the whip end of this thing, and whatever happens, she just kind of has to watch and wait for the outcome and isn't entitled to any relief, even if her attorney's fees are huge and she gets the same verdict she got before. Is that correct?
That I believe is their position, and Your Honors, that I would submit that would be unfair even if there wasn't direct adversity between the two defendants. But I would submit that in this case, given the direct adversity, that it's even a more compelling position because Fisher wanted us in this appeal. And this was, I read from the joint pretrial statement at the trial. This was a main issue in the trial. Now, I'm sorry, Judge Jones, you look like you were...
Under Valor, you said Fisher wanted Edgerton in this appeal. I think everybody agrees that under Valor, Edgerton was going to be in this appeal.
I don't necessarily agree with that.
You don't think that in a comparative fault case that all the parties that are going to be subject to potential fault claims need to be included in the trial de novo?
No, I don't. And let me explain. And I would say, Your Honors, I don't believe that this issue is determinative, but I don't believe that they have to. And I would, if you look at Valor versus Lee, all the court there decided in that particular case there was an appeal by one defendant, and that appellant included, the whole 9 yards, including the other defendant. Now, the non-appealing defendant filed a motion in that particular case saying the arbitration award is final to me. The trial, what the Court of Appeals said is when you try to do that in over-objection of the other parties, you can't get out. So in this case, if I had filed a motion to get out over objection of the other parties, I couldn't have gotten out. But that case did not hold, Your Honors, that it has to all be included. There is dicta to that effect. There's absolutely no dispute about that. But when you look at the holding of the case, it did not hold that you always have to take the entire case up, even in a negligence situation. And, Your Honors, I'm going to direct you to the Orlando decision from this court that's cited in the appellant's brief, where the court said, we hold that when joinder is not required, an appeal of an arbitration award is only effective as to the party appealing the award and the party or parties named in that appeal. Now, that case did distinguish Valder and said, well, it's a negligence case. But in this particular case, Your Honors, I would submit that Fisher could have filed an appeal and only appealed the issue vis-a-vis the plaintiff. That could have been done, I would submit, Your Honors.
Can you say that then the plaintiff wouldn't have objected that if you're going to start apportioning at a trial de novo the liability, that it's essential that Edgerton be a part of it?
I think the plaintiff absolutely could have taken that position. But if Fisher and the plaintiff were in agreement, we did not need to be in this appeal.
Well, that's the stipulation.
Yeah.
That's the stipulation.
You could do it by stipulation, certainly, Your Honor.
But what do you do if Fisher appeals and she doesn't try to shift liability to Edgerton? I know that's not this case.
Right.
So now it's really plaintiff versus Fisher and Edgerton gets 0.
Okay.
Do you get fees against, and so there's no improvement.
Right.
You can't get fees against the plaintiff. You're Edgerton. You can't get fees against the
Right.
plaintiff. Can you go against Edgerton? Get fees against Edgerton? I'm using against Fisher if Fisher didn't try to shift liability?
You know, Your Honor, it's like what I said before. I said, I think that it's not determinative that they took the affirmative position here to shift liability. I think that we would be entitled anyway, but I think it's a more compelling case where we have a case like this one where they were affirmatively attempting to shift fault on us. If that were not the case, hypothetically, Your Honor, I still think that we're in the appeal and we're the prevailing party vis-a-vis that defendant, and we'd be entitled to them.
But then in that situation, you're really not adverse to Fisher.
That's true, but they were still the appellant and included us in the appeal. But fortunately, Your Honor, that's not this case.
Oh, that's right. And we don't have to deal with that.
But that's why I say, previously, I don't think it's determinative, but I do think it's a compelling reason here as to why fees were appropriately awarded by the trial court. But in any event, whether they had to name us or not, I would submit that is a red herring. At the end of the day, we're in this appeal, and Fisher appeals, they lost, and we won, and we should not have been involved in it. And I would submit, Your Honor, you cannot kind of go full circle on this. You cannot avoid fees by simply saying, well, I won another part of the case. That's really what it all comes down to. They say, well, I won part of this case, and therefore I shouldn't have to pay sanctions to one party. Let me posit in closing on this issue one other hypothetical. What if Fisher did not do 23% better vis-a-vis the plaintiff, but in fact got 24% of the fault shifted to us? In that particular situation, could Fisher award or avoid fees vis-a-vis the plaintiff by saying, oh, but I did better against the defendant, so when you look at this as a whole, I actually did better? I would submit absolutely not, Your Honors, that you cannot parse this out as they are suggesting by saying I won part of the case and therefore I can avoid fees. I will address briefly on the constitutional issue, Your Honors. I would submit, when you look at an issue like this, and the issue is, does this unreasonably infringe upon my right to a trial by jury? I would submit, Your Honors, that the arbitration rules and these sanctions, they are intended to discourage jury trials. Of course they are. That's why we have this whole process. They discourage them, but that doesn't mean that there's a constitutional violation. The cases in other jurisdictions have unanimously held that similar arbitration provisions are constitutional. I would submit you always have the trial court there who can determine what's reasonable. The rule says that you can award reasonable attorney's fees. Sanctions are mandatory in a given situation, but the trial court can always determine what's reasonable.
given your raising of this issue of the trial court deciding what is reasonable, how is 77F, the award in 77F, and the trial court's right to determine what's reasonable, how is that different than a 12-34101 award in contract debate? Contract dispute?
Well, I think it's different in one sense because in 12-34101, an award at all is discretionary. I mean, the court always has the discretion whether to make an award of a fees at all. And then, if you decide to award fees under the statute, you then determine what's reasonable. In this case...
But it ultimately comes down to a reasonableness determination by the court, not some mandatory decision by someone not in the best position, i.e. maybe even a jury, to award an amount of fees, correct?
Yes. I believe that's correct. And Your Honors, what makes these arbitration rules constitutional, and Valder versus Lee actually said this, is the trial de novo right. You always have the right to take a trial de novo. The fact that, though, there is the possibility of some attorney's fee award or costs does not unduly infringe upon the right to jury trial. Any litigant in any scenario faces that prospect. And it's no different when you take an appeal from an arbitration award. Any litigant has to pay costs. I have to pay a filing fee. That doesn't infringe my right to a jury trial. Were you going to say something, Judge Jones? I thought
Filing fee was something I'd considered early in this debate.
Yeah, and any litigant has the prospect of losing and having a cost award. Any party to an arbitration that appeals has the prospect that it might have to pay some sanction. But that prospect does not unduly infringe upon the jury trial right. And I go back to, you ultimately have the buffer of the trial court being in the position to determine what was reasonable in this particular case.
And the party's ability to debate what is reasonable.
Certainly, Your Honor. And there's no claim here that that the award here was in an unreasonable amount. And therefore, I would submit that their constitutional argument really attacks the entire arbitration process and the sanctions that are awarded. But
technically, they're not sanctions. They're really just fees.
I think you're probably right. And a lot of lawyers, myself included, as I just demonstrated, call them sanction. It's probably just a fee award, and I think you're right, Judge. But there was no unreasonable amount here, and I would submit they're really attacking the entire process. But there isn't, and I know, Judge Kessler, you act, there isn't a case in any similar situation in any other jurisdiction that have found this process to be unconstitutional, and as long as you have that de novo right to jury trial, it is constitutional. And
you're saying there's no other case in any other jurisdiction that's addressed it, or
no. We cited that it has been addressed. We cited 3 cases in our brief in other jurisdictions that have found similar statutory provisions to be constitutional, and there isn't a case that we've seen that has found one to be unconstitutional. And so, Your Honors, unless you have other questions, that's all I have.
Thank you.
Thank you.
Your Honors, I think we can all agree that Valor required Fisher to name Edgerton. I heard Mr. Thomason say he doesn't agree with that, but that's what the case says. Fisher did not want to name Edgerton. She could care less about Edgerton. If she could, of course she's going to say that the comparative fault is on Edgerton, but that doesn't do anything as to her. That only affects plaintiff. It just doesn't matter.
That only affects plaintiff. So we're back to what I was asking early on. In comparative fault circumstances, in a comparative fault circumstance, you're saying it only affects plaintiff in regard to his ability to collect the entirety of his judgment.
Right.
Okay, good.
And I don't know, this issue hasn't come up. I don't know if Peterson could have collected anything from Edgerton. She didn't appeal. The arbitration award as between Peterson and Edgerton is a 0 verdict. Can she collect? I don't know. The problem here is that the rule does not address multiple parties, and every court that has looked at it, the Supreme Court and this court, have said somebody needs to look at the rule and decide what's happening.
So you'd
But-
like us to amend the rule?
Excuse me? No, you can't
Can't
amend
do
the
that.
rule. I understand you can't amend the
argument is
rule.
to petition
And so
and change
let's
the-
look at what was intended here. What we're doing is sanctioning Fisher because she had to do something the law required her to do, against her will. It didn't matter to her whether Edgerton was a party or a non-party at fault, or
She could have sought to stipulate that Edgerton should not be a party to the appeal.
well, if
Done that, and
if
then
she,
it was up to Fisher, and then you might have an argument that, well, I was forced to do this, but
If-
of course you also tried to shift liability to Edgerton.
if
So-
she had noticed that there was any possibility that, and remember, there's no case anywhere in the country that has held sanctions from one defendant to a, from defendant to a co-defendant, there's no notice here. That's a violation of due process. She
Not true.
can't decide
Isn't that
here.
true? Every attorney, I mean, wouldn't 12-341-01 also be unconstitutional? Because there's no notice about what the award might be.
Oh, I disagree, Your Honor. There should be no award here. It's a difference between thinking about the amount of the award and when
Yes,
whether
notice
there
that-
should be
well, she
any
clearly has noticed there might be an award.
against the plaintiff, against the party she's appealing against. My time has run out, and
You may have heard we have another case after this to address.
I
Going to
understand.
be
Your
here for
Honor.
that?
Counsel, thank you for your argument. It has been helpful in an area where there clearly are clouds present. As you say, there's very little, if any, law addressing these particular issues. We appreciate your discussion in that regard. This matter is taken under advisement at this time, and we will rule in due course. Thank you. We're adjourned.